A woman takes her dog for a walk on an ordinary summer afternoon in a small English village. Half an hour later, the dog comes home alone. That's the moment everything changes. What follows is a 15-year fight for justice. A killer acquitted in under an hour, a jury foreman who later wrote to congratulate him, and a change in English law so significant it would go on to reopen decades of cases that everyone thought were closed forever. This is the story of Vicky Thompson. On the 12th of August 1995, at around 4 o'clock in the afternoon, 30-year-old Vicky Thompson left her home in Ascot under Wychwood, a small village in the Cotswolds, Oxfordshire. She lived there with her husband Jonathan and their 2 young children, Matthew and Jenny. She took the family dog, Daisy, out for what should have been a short, completely unremarkable walk, the kind of everyday errand repeated in villages across Britain 1,000,000 times over on any given afternoon. She never came home. What happened next unfolded with a speed that must have felt like the ground opening up beneath an entire family. The dog came back, alone, no lead trailing behind her, no sign of Vicky anywhere. For any parent, any partner, that image alone, a family pet returning home without the person who took it out, is one of the most immediately alarming things that can happen on an ordinary day. Jonathan and his neighbours didn't wait. They went out looking straight away, and for more than 3 hours, nobody knew where Vicky was, or what had happened to her. She was finally found at around 7:15 that evening, more than 3 hours after she'd first walked out her front door. She was alive, but she had been savagely beaten, and she'd been placed near a railway line, in what investigators would come to believe was a deliberate attempt to disguise what had actually happened to her, to make it look as though she'd been struck by a train rather than attacked by another person. Vicky fought for her life for 6 more days in hospital. She did not survive. Here's what had actually happened to her, in the few minutes it took to change everything for her family forever. Vicky, walking her dog near a railway line close to her village, had stumbled upon a local man named Mark Weston. He was masturbating in public near the tracks. She saw him, and in that single moment, an ordinary dog walk turned into something no one could have predicted. Weston picked up a rock. He hit her over the head with it. Then, according to the case that would eventually be built against him, he placed her on the railway line itself, staging the scene to look like a train accident rather than the assault it actually was. Police built a case against Weston fairly quickly. He became the prime suspect, and investigators worked to put together enough evidence to charge him with murder. The case went to trial at Oxford Crown Court in 1996. The jury found him not guilty. It took them 50 minutes. 50 minutes to acquit a man of murdering a young mother of 2, beaten with a rock and left for dead beside a railway line. Weston walked free. And in one of the most extraordinary details in this entire case, the foreman of that jury, the person whose job it had been to weigh the evidence and reach a verdict on behalf of everyone in that courtroom, later wrote a letter to Mark Weston. He wished him luck. He urged Weston to pursue the police for compensation, suggesting that Weston himself had been wronged by the investigation. Sit with that for a second. A man acquitted of murdering a mother of 2 receives a personal letter from his own jury foreman, congratulating him and encouraging him to sue the police who had investigated him. For Vicky's family, that verdict meant living with something almost unbearable, knowing, in their hearts, exactly who they believed had killed her, and watching that same man walk free, protected by one of the oldest legal principles in English law. Double jeopardy. Once acquitted of a crime, you cannot be tried again for that same crime. Not with new evidence, not with a confession, not with anything. The law as it stood in 1996 meant that whatever happened next, whatever new evidence might one day surface, Mark Weston could never again face a jury for Vicky Thompson's murder. That's not a small legal technicality. That's a wall, built into the foundation of the entire justice system. And in 1996, it looked completely immovable. 10 years passed. In 2005, on the 10th anniversary of Vicky's death, something changed that had nothing to do with new evidence at all. It was a change in the law itself. The double jeopardy rule, that ancient principle protecting Weston from ever facing trial again, was reformed. For the first time in centuries, English law allowed prosecutors to retry someone for the same crime, but only under very specific, tightly controlled circumstances, if genuinely new and compelling evidence emerged that hadn't been available at the original trial. Thames Valley Police didn't let that anniversary pass quietly. They reopened Vicky's case as part of a formal cold case review, betting that somewhere in the physical evidence collected back in 1995, evidence that the forensic science of the mid-90s simply hadn't been sensitive enough to properly analyse, there might be something the original investigation had missed. They were right. Weston's boots, seized as evidence back in 1995 and sitting in storage ever since, were resubmitted for testing using forensic techniques that simply hadn't existed a decade earlier. And on those boots, investigators found something the original 1996 trial never knew was there: tiny, trace amounts of blood. When that blood was tested, it matched Vicky Thompson. That discovery alone would have been significant enough to reopen this case. But it wasn't the only piece of new evidence investigators uncovered. They also found something else entirely, something that had nothing to do with forensic science and everything to do with Weston's own words. A text message sent from Weston to his ex-girlfriend at some point in the years after his acquittal. That read, "I killed her, and I would do the same to you." Read that again. A man, already acquitted, already protected by double jeopardy, already free to live his life exactly as he pleased, sent a text message to a former partner admitting, in his own words, that he had killed Vicky Thompson. And then he threatened to do the same thing to her. Between the blood on his boots and his own written confession, sent from his own phone, Thames Valley Police finally had what they needed. Weston was arrested again on the 21st of October, at his home, the same village of Ascot under Wychwood, where Vicky had died more than a decade earlier, using the newly reformed double jeopardy law. Prosecutors applied to have his original acquittal overturned, so that he could face trial a second time for the same murder. The second trial took place at Reading Crown Court. A new jury, 7 men and 5 women, heard the case laid out in full, the forensic evidence linking Weston's boots to Vicky's blood, the confession sent by text message years after his original acquittal, and the full account of what had happened on that railway line back in August 1995. This time, the jury took just under 4 hours to reach their verdict. Guilty. There were gasps and sobs from the public gallery when that verdict was read out. 15 years of waiting. 15 years of knowing exactly who was responsible while watching him walk free. 15 years of a family living with an injustice the law itself had made permanent. All of it finally, definitively resolved in one moment in a Reading courtroom. Weston, dressed in a white shirt and a blue and black tie, showed no emotion whatsoever as the verdict was delivered. On the 13th of December 2010, Mark Weston was sentenced to life imprisonment, with a minimum term of 13 years. He became the very first person in English legal history to be convicted using new forensic evidence following the reform of the double jeopardy law. Not the first person retried under the new legislation, the first person specifically convicted because forensic science had advanced enough in the years since his original trial to find something the 1996 investigation had entirely missed. Vicky's husband, Jonathan Thompson, spoke outside the court after the verdict. He said that Vicky's family had been through agony, that they had been exceptionally patient waiting for this moment to finally arrive, having had to live for so many years with the fact that whoever had done this to Vicky was walking free, not in prison, not held accountable, simply out there, living his life. Let's slow down on that phrase, because it captures something that so many families in cases like this one carry silently for years, having to live with the fact that whoever did this was not in jail. That's not simply grief. It's a specific, ongoing kind of injustice. Knowing exactly who took someone from you, having watched a court supposedly examine all the evidence, and then having to continue existing in the same world, sometimes even the same village, as the person you believe responsible, protected entirely by a legal principle that exists for good reasons in most cases, but that, in this particular one, functioned as a permanent shield for a killer. Think about what it must have been like for Jonathan Thompson and his children Matthew and Jenny, growing up in the years after their mother's death, in a small Cotswolds village where everybody would have known exactly who Mark Weston was, exactly what he'd been accused of, and exactly how that first trial had ended. A village that size doesn't forget something like that. Every trip to the shop, every school run, every ordinary errand carried the possibility of crossing paths with the man a jury had acquitted in 50 minutes. The same man whose own jury foreman had written him a letter of encouragement afterward. That's the reality Double Jeopardy created for this family for a full decade. Not closure. Not even the uneasy peace that sometimes comes with a conviction you disagree with, but total, permanent legal silence on the subject, with absolutely no path forward until the law itself finally changed. It's worth understanding just how significant that legal change actually was, because Vicky Thompson's case became one of the clearest, most powerful illustrations of exactly why reforming Double Jeopardy mattered. The principle exists, historically, to protect innocent people from being repeatedly hauled back into court by an overzealous state, tried again and again for the same alleged crime, until a prosecutor finally gets the verdict they want. That's a real and important protection in a fair justice system. But it was never designed to account for a specific modern reality, that forensic science keeps advancing long after a trial concludes, and that evidence sitting quietly in storage, evidence the original investigators simply didn't have the tools to properly analyze, might one day be capable of proving, beyond any reasonable doubt, exactly what happened. Before 2005, English law had no mechanism at all for accounting for that gap between the science available at trial and the science available years, sometimes decades, later. Once you were acquitted, forever, regardless of what technology might eventually reveal. Vicky Thompson's case, alongside a small handful of others working through the system around the same time, became part of the evidence that persuaded lawmakers this rigid, absolute version of double jeopardy needed a narrow, carefully controlled exception. That exception had to be strict, and deliberately so. It couldn't simply allow prosecutors to keep retrying anyone they still suspected, using flimsy or recycled evidence dressed up as something new. The reformed law required genuinely new and compelling evidence. Evidence that hadn't been available or hadn't been properly understood at the time of the original trial. In Weston's case, that bar was met twice over, once through advanced forensic testing that found blood the original investigation had entirely missed, and again through a chilling piece of digital evidence, a text message sent from his own phone, in his own words, admitting exactly what he'd done. There's something worth sitting with in the fact that it was Weston's own words, sent casually to an ex-girlfriend years after he thought he'd gotten away with everything, that helped bring him back to court. He wasn't caught out by some elaborate sting operation or a mistake made under police interrogation. He simply told someone, in a moment of anger or arrogance or whatever motivated that specific message, exactly what he'd done, apparently confident that nothing could ever touch him again. That confidence, built entirely on the old double jeopardy rule, on the belief that acquittal meant permanent safety no matter what, turned out to be exactly the kind of arrogance that so often trips up people who believe they've truly gotten away with something. What does it actually feel like to sit in a courtroom 15 years after your wife's murder, watching a jury finally, definitively convict the man you always believed was responsible? Jonathan Thompson's own words afterward, describing agony and exceptional patience, only begin to capture it. 15 years is long enough for children to grow from toddlers into young adults, entirely shaped by growing up without their mother, and by living, for most of that time, in a village where her killer walked free among them. Vicky Thompson was 30 years old when she died. She was a mother of 2 young children. She left her home on an ordinary August afternoon to walk the family dog, exactly the kind of small, unremarkable task that happens in every household, everywhere, every single day. She stumbled into something she had absolutely no reason to expect, a stranger's shameful private act carried out in a public place, and paid for that chance, unwanted encounter with her own life. Mark Weston's crime wasn't planned in advance in the way some of the most calculated murders are. It appears, from everything known about the case, to have been a violent, desperate act of self-preservation, an attempt to silence a witness to something he was deeply ashamed to have been caught doing. That doesn't make it any less brutal. If anything, it makes the staged railway scene, the attempt to disguise her injuries as the result of a train collision rather than a deliberate assault, feel even colder. A man calculating, in the immediate aftermath of what he'd just done, exactly how to escape the consequences of it. And for a while, that calculation worked. It worked for 15 years. In fact, protected by a legal principle that had existed, largely unchanged, for centuries before anyone had ever heard of DNA profiling or forensic blood analysis, capable of detecting traces invisible to the techniques of the mid-1990s. What ultimately undid him wasn't a single dramatic breakthrough, but the patient accumulation of exactly the kind of evidence that modern forensic science makes possible. Physical evidence sitting quietly in an evidence store for a decade, waiting for the technology to catch up with it. Combined with the kind of digital trail that simply didn't exist in the same way back in 1995. A text message capable of surviving on a phone or a network's records for years. After it was sent, ready to be recovered the moment investigators had reason to look for it. Let's go back to that scene by the railway line for a moment, because the specific details of what investigators found there in 1995 tell you a lot about how difficult this case was from the very start. When Vicki was found, more than 3 hours after she'd left home, she had suffered severe head injuries consistent with a violent blow. She was placed near the railway line itself, and investigators had to work out in those first critical hours whether they were looking at a genuine accident, a woman struck by a passing train, or something else entirely, staged to look that way. That distinction matters enormously in the earliest stages of any investigation, because it determines everything that follows, whether you're treating a scene as a tragic accident, requiring a straightforward report, or as a crime scene requiring the full weight of a murder investigation, with all the evidence preservation and forensic care that requires. Whoever attacked Vicki clearly hoped investigators would conclude the former. Placing her body near the tracks was a deliberate attempt to manufacture an alternative explanation for her injuries, one that wouldn't point back toward a specific attacker at all. It's a chillingly practical piece of thinking for what appears to have otherwise been an impulsive, unplanned act of violence. A man who had just been caught in a deeply shameful private moment, reacting first with violence, and then, almost immediately afterward, with enough presence of mind to try to disguise what he'd actually done. That staging didn't fully work, of course. Investigators in 1995 were skilled enough to recognize injuries inconsistent with a train collision, and skilled enough to identify Mark Weston as a viable suspect worth building a case against. But it likely brought him something almost as valuable in the earliest hours of the investigation: time, confusion, and just enough ambiguity to complicate the picture investigators were trying to piece together. The original 1996 trial rested heavily on circumstantial evidence and whatever physical evidence investigators had been able to recover and test using the forensic techniques available at the time. This is worth understanding clearly. The blood on Weston's boots was there in 1995. It just wasn't detectable yet, not with the sensitivity of testing equipment available in the mid-1990s. Forensic science has advanced dramatically since then, particularly in its ability to identify and analyse extremely small, trace amounts of biological material that would have been completely invisible to earlier techniques. A stain too small or too degraded to register on 1995 equipment can, with modern methods, yield a full and reliable genetic profile. This is precisely why cold case reviews matter so much, and why police forces across Britain have increasingly prioritized revisiting historical unsolved or wrongly resolved cases specifically to reapply modern forensic techniques to evidence that was properly preserved at the time but simply couldn't be fully analysed with the tools available back then. Vicky Thompson's case stands as one of the clearest, most consequential examples of exactly why that patient methodical work matters. Without Thames Valley Police specifically choosing to reopen this file on the 10th anniversary of her death and resubmit Weston's boots for renewed testing, that crucial blood evidence might never have been found at all, and Weston might have remained protected by his 1996 acquittal for the rest of his life. There's a particular kind of frustration built into working a case like this one from a detective's perspective. Investigators in 1996 almost certainly believed they had the right man. The circumstantial case against Weston, his presence near the scene, whatever behavioural or contextual evidence pointed toward him, was compelling enough to bring formal murder charges. But circumstantial evidence alone, however compelling, isn't always enough to overcome reasonable doubt in the eyes of a jury, particularly when a defence can point to the absence of any definitive forensic link, placing their client directly at the scene of the violence itself. That's exactly the gap the blood on Weston's boots eventually closed. It transformed a case built on circumstance and suspicion into one anchored by direct physical evidence, Vicky's own blood, on the boots belonging to the man already suspected of killing her, missed entirely during the first investigation, and finally recovered a decade later using techniques that simply hadn't existed the first time around. Let's also spend a moment on the text message, because as chilling as it is, it also tells us something important about how digital evidence has transformed criminal investigations more broadly since the mid-1990s. In 1995, there was no meaningful equivalent of a text message trail for investigators to draw on. Mobile phones existed, but the kind of routine. Casual digital communication that now leaves a permanent, recoverable record simply wasn't part of everyday life yet. By the time Weston sent that message to his ex-girlfriend, years after his acquittal, the entire landscape of personal communication had changed. Messages sent from mobile phones could be retained, recovered, and used as evidence in ways that simply weren't possible when Vicky was killed. Weston, it seems, either didn't fully grasp how permanent and recoverable that kind of digital communication had become, or simply didn't think anyone would ever have reason to go looking for it. Either way, that single message, sent in what may have been a moment of anger, arrogance, or an attempt to intimidate a former partner, became one of the two pillars that finally brought him back to justice, sitting alongside the forensic breakthrough on his boots as the new and compelling evidence the reformed double jeopardy law specifically required before a second trial could even be considered. It's worth pausing on the particular cruelty embedded in that text message too. "I killed her and I would do the same to you" isn't simply a confession. It's a threat, directed at a woman who had presumably ended a relationship with Weston, delivered with the casual confidence of someone who believed, correctly for a full decade, that the law could never touch him again for what he'd already done. That combination, confession and threat, delivered in the same breath, reveals something troubling about how completely Weston had internalized his own untouchability. How thoroughly the old double jeopardy rule had convinced him that Vicky's murder was simply a closed chapter of his life, rather than something that could ever resurface to hold him accountable. For the wider community in Ascot under Wychwood, and for villages like it across the Cotswolds, this case left a lasting mark that extended well beyond the Thompson family themselves. Rural English villages of this size operate on a particular kind of intimacy and familiarity, everyone recognising everyone else, children growing up alongside each other, families embedded in the same small community for generations. A murder investigation, an acquittal that split public opinion, and a suspect who continued living in that same small community for years afterward, would have left an unmistakable and lasting undercurrent of unease running beneath the surface of everyday village life. That unease didn't fully resolve until 2010, 15 years after Vicky's death, when Weston was finally convicted. For an entire generation of people living in and around Ascot under Wychwood, that conviction closed a chapter that had remained stubbornly, uncomfortably open for the length of an entire childhood. Matthew and Jenny Thompson had grown from small children into young adults during those 15 years, shaped by growing up without their mother and by living, for most of that time, in the same community as the man their family always believed had killed her. Vicky Thompson's case changed English law. It stands today as one of the defining early examples of the double jeopardy reform actually working exactly as intended, not as a tool for repeatedly harassing people the state merely suspected, but as a narrow, carefully justified exception that finally allowed genuinely new, compelling evidence to override an acquittal that had, in hindsight, been based on an incomplete picture of what had actually happened. For her family, none of that legal significance ever mattered, as much as the simple fact of finally seeing Mark Weston convicted, 15 years after he took Vicky from them, and after 15 years of watching him live freely in their own community, protected by a rule of law that had, for a full decade, functioned as nothing more than a shield for exactly the kind of guilt his own text message would eventually confirm. Vicky Thompson took her dog for a walk on an ordinary August afternoon in 1995 and never came home. It would take 15 years, a change in English law, advances in forensic science, and, in the end, Mark Weston's own careless words to a former partner, for her family to finally get the justice that a jury's 50-minute deliberation had denied them back in 1996. That's the story of Vicky Thompson, and it remains, to this day, one of the clearest illustrations in modern British legal history of exactly why the old absolute version of double jeopardy needed to change, and exactly what can happen when it finally does. There's one more thread in this story worth pulling on before we close, and it's about that jury foreman's letter, because it deserves more than a passing mention. Think about what that letter actually represents. This wasn't a random member of the public writing to Weston out of some misguided sympathy after reading about the case in a newspaper. This was the foreman of the actual jury that had just acquitted him. Someone who had sat through the entirety of the 1996 trial, heard all the evidence the prosecution had available at the time, and reached, alongside 11 other jurors, a unanimous or majority decision that Weston was not guilty. And then, afterward, that same person felt moved enough to write to Weston personally, not simply to wish him well, but to actively encourage him to pursue financial compensation from the police for having investigated him in the first place. That detail tells you something important about how completely the 1996 trial had been shaped by the forensic limitations of the era. Without the blood evidence that would only be uncovered years later, without the text message that hadn't even been sent yet, the case against Weston in 1996 rested on evidence that, apparently, struck at least one juror as not just insufficient for a conviction, but as actively unfair to the man standing accused. That's how thin the case looked at the time, through the eyes of the very people tasked with weighing it. It's a sobering reminder of just how much the eventual outcome of a criminal trial can depend on what forensic technology happens to be available at that specific moment in history, rather than on the underlying truth of what actually happened. In 1996, without modern trace DNA analysis, and without any digital confession to point to, a jury looked at the case against Mark Weston and didn't just fail to convict him, they very nearly took his side entirely. Sympathetic enough to his position that one of their own number reached out afterward to encourage him to sue the very investigators who had, it would turn out 15 years later, been right about him all along. That's perhaps the most quietly devastating detail in this entire case. It wasn't simply that Weston escaped justice for a decade and a half. It's that for a period of time, the system built to deliver justice actively worked against Vicky Thompson's memory, treating the man who killed her not as someone who had gotten away with murder, but as someone who deserved sympathy and compensation for having been wrongly suspected in the first place. It took new blood evidence and Weston's own reckless words, sent years later to a woman he was trying to threaten, to finally correct that record and give Vicky's family the outcome that should have been possible from the very beginning. If only the forensic science of 1996 had been capable of finding what was already there, waiting on a pair of boots, the entire time. Vicky Thompson took her dog for a walk on an ordinary summer afternoon and never came home again. 15 years later, justice finally caught up with the man responsible, not because the system suddenly worked faster or better, but because science advanced enough to find what had been there all along, and because a killer, confident he could never be touched again, made the mistake of putting his own guilt into words. That combination, patient forensic work and one careless confession, is what finally gave Vicky's family the only thing they'd been waiting 15 years for. The truth, spoken aloud in a courtroom, and a verdict that could never again be taken away.